Thank you, Your Honor. Your Honor, I represent Lincoln County and the Sheriff of Lincoln County, Rick Bearden. There's a reason why we have separate attorneys, and that's because, for defendants, and that is because Lincoln County and Sheriff Bearden and their
You're representing him in his official capacity?
Yes, sir.
Okay.
Yes, sir. And as far as I know, Sheriff Bearden is not sued in his individual capacity. So, okay. So I represent the sheriff and the county, and our legal position is very distinct and different and apart from the other defendants, Cedarwall and Sullivan. That's why we have separate attorneys. Your Honor, the amended complaint, the first amended complaint here mentions IPRA requests on April 24, 2007 and May 9, 2007. Those are the IPRA requests at issue here before you, Your Honor, as set forth in the complaint. Now, I'm glad that Ms. Cooper brought forth before you the recent case in the Second Judicial District involving Plaintiff Vega Brown and Defendant Bernalillo County, because this case emphasizes my legal position on behalf of Lincoln County and the Sheriff of Lincoln County before you today. If Your Honor will look at page 4 of the opinion which we received today from the plaintiff, from Dr. Cooper, I will read the following language from that opinion by Judge Campbell at the bottom of the page, Your Honor, citing the statute. A custodian who does not deliver or mail a written explanation of denial within 15 days after receipt of a written request for inspection is subject to an action to enforce the provisions of IPRA, and the requestor may be awarded damages. Such damages shall, paragraph 1, be awarded if the failure to provide a timely explanation of denial is determined to be unreasonable. 2, not exceed $100 per day. It doesn't say it's $100 per day. It says not exceed. 3, accrue from the day the public body is in noncompliance until a written denial is issued. And 4, be payable from the funds of the public body. That's at section 14-2-11. Now here, Your Honor, the IPRA requests of 42407 was timely responded to by the county, by Attorney Alan Morrell, and the IPRA request of 5907 was likewise timely responded to. The first response was sent on 42707, and the second response was sent on 51107. So each response was sent within 3 or 4 days of the IPRA request. The responses said, we don't have the records you are seeking, because they were seeking DNA records, which were not in the sheriff's office, or records of the sheriff's office. The response also said, and Mr. Morrell and the sheriff made it clear, if you want to come and look at anything in the sheriff's file, you're welcome to do so. So unlike the case in Bernalillo County, Lincoln County made timely responses with explanations. So there is no legal basis, Your Honor, for granting up to $100 per day. It's not here as a matter of law against Lincoln County or the Sheriff of Lincoln County. Now, this court held a hearing, one of at least 4 or 5 hearings, in January of 2011. Your Honor held an evidentiary hearing. Following that evidentiary hearing, this court issued an order finding specifically that Sheriff Bearden had turned everything he had over related to the investigation. Under those circumstances, Your Honor, there is no basis for making any award for damages against Lincoln County or the Sheriff of Lincoln County. And that's all we're here about today, damages and costs, because there is no claim for attorney fees here before you today. All of the attorney fees have been settled and paid. So, when it comes to Lincoln County, this is a very simple case. One of the IPRA requests, which is not included, by the way, in the first amended complaint, was an IPRA request on 6/14/07, June 14 of 2007. And those IPRA requests were sent to Sullivan and Cedarwall. And Alan Morrell, sitting here today, testified before you, Your Honor, in regards to that IPRA request, or requests, it was the same, they were identical, of June 14, 2007. Alan Morrell sent a letter from the sheriff. The sheriff and Alan Morrell hand-delivered the letter to Sullivan and Cedarwall. It said, look, we've got this IPRA request. Give us everything in your possession. We want to put it in the sheriff's office file, and we want to turn it over. Give it to us. And that letter was dated June 21, and on June 22, when they met to deliver the letter, Sullivan and Cedarwall instead turned in their sheriff's commission cards. What was Lincoln County to do at that point? What does the law require Lincoln County to do? What more could Alan Morrell do? And he sat here and testified to you, Your Honor, and you and I were both asking him, couldn't you have tried something else? Well, what else could he have done? Could he have tried to issue a subpoena to Sullivan and Cedarwall? Is that what IPRA requires? Does IPRA require you to grab the employee who turns in his resignation, in effect, and say, give me those files, or I'm going to what? I'm going to fire you? You can't fire you. They quit on you. What can you do, Your Honor? I put it to you. I think all you can do is tell them you've got to give it to us or else, and then they quit. I don't know that the law requires Lincoln County to do anything further to protect the taxpayers of Lincoln County from this type of lawsuit. What more can the officials of Lincoln County do to protect the taxpayers? I cannot think of anything else that can be done. If Your Honor or plaintiff can think of something else, I'd like to hear it. But I haven't heard it yet. And we had that hearing before you, Your Honor. Alan Morrell sat here and said, as the attorney for Lincoln County, I did all I could. What more could I do? Now, the information sought in these IPRA requests related to DNA information. Again, it was not in the sheriff's possession. There's nobody here saying that it was in the sheriff's possession. The court asked us to send letters, and we did send letters. We sent letters to Orchid and to Lee. Those were sent on or about October 26, 2010. Orchid Cellmark responded on November 2, 2010 to the sheriff and said, we're sorry, but this is confidential information available only to our client, and you are not our client, so they wouldn't give it to us. And Orchid Cellmark and Henry Lee are both out of state. They're not within New Mexico. Henry Lee likewise declined to provide the information. Eventually, this information was obtained after subpoena duces tecums were served on them by attorneys in the lawsuit. Was Lincoln County required to serve subpoenas upon Orchid Cellmark and Henry Lee, two out-of-state actors, to obtain the requested information, which was not in the file of the Sheriff of Lincoln County? I do not believe that would be the legal requirement of the IPRA Act, Your Honor, and no one is suggesting that. Judge, this is a case, as I understand it, for damages under 14.211, up to $100 based upon a determination that Lincoln County and the Sheriff of Lincoln County did not submit timely responses with explanation. We have those timely responses with explanations before you. They are exhibits before you. We had the author, Alan Morrell, testify to you. I believe we have fully and completely satisfied what was required of us. I do not believe there was anything else that could be reasonably done under the Act to satisfy these IPRA requests. We have submitted requested findings and conclusions to you, Your Honor. They were submitted on April 24, 2013, pursuant to your court order. We would request that you adopt those findings and conclusions which we have submitted on behalf of Lincoln County and the Sheriff of Lincoln County, which essentially set forth what I have just proposed to you, Your Honor. There is no evidence about costs of $19,500 as claimed by the plaintiff. I'm not saying she doesn't have such costs. I'm saying I don't know. There's no such evidence. There certainly is no basis for an award of $100 a day or any award or any penalty or any fine against Lincoln County and the Sheriff. And let me say, there is no basis for awarding such a penalty or fine that the taxpayers of Lincoln County will be forced to bear. Under these circumstances, Your Honor, we would respectfully request that you enter the findings and conclusions which we have submitted and which are in accordance with the evidence submitted in this case and the law of this case, and which are consistent with your finding following the January 2011 hearing that the sheriff produced everything in his file. Thank you.
Sure, right. Let me ask a couple first. I know you represent the county and the sheriff.
Yes, sir.
But one of the key words that you used was Sandoval being an employee, and I know he was an employee that was being paid and so forth, but he was under commission from the sheriff. I think also made a finding some time back that he was acting as basically an agent for the sheriff. And I know what you're saying is you represent the county, you represent the sheriff. You don't represent Sandoval, who I've already found was acting as an agent for the county. So how do we get around that? And I know he's not your client.
Your Honor, I maintain, first of all, I do not represent Sandoval. It is my view that when Sandoval refused the direction of the county and the sheriff to turn over those materials, he was acting outside the course and scope of his employment. That's why he needs his own attorney in this case, Your Honor. I maintain that the minute he refused to turn over those documents, he ceased being an agent of this Lincoln County. That's my view. Thank you, sir.
May I do the rebuttal so it doesn't build up?
Let me hear her first and we'll do your rebuttal.
afternoon, Your Honor. Desiree Goulet on behalf of Defendant Cedarwall, and as we discussed earlier, Defendant Sullivan will be dismissed pursuant to Rule 41 voluntarily upon stipulation, so I'll only make arguments at this time in regard to Mr. Cedarwall if the court is in approval. Thank you. Your Honor, the joint motion, the joint response to Dr. Cooper's motion filed on May 23rd, 2013 was filed in for two reasons in the manner that it was. The first reason was that in regard to this new May 23rd, 2013 motion, there are no new evidence or no new facts or no new proceedings which have occurred before the court in this very long course of litigation which would merit a new motion or new findings by the court in regard to either fact or law other than what has already been proposed and submitted to the court pursuant to the order requiring proposed findings of fact and conclusions of law by the date in April this year, which all parties have complied with. There's no argument by Mr. Cedarwall that has not been the case. However, what Mr. Cedarwall argues is that this May 23rd motion and then the later addendum filed 7-1 of 2013 serve the purpose of effectively just constituting a supplementation, if you will, to Dr. Cooper's proposed findings of fact and conclusions of law, which were initially filed in February. And what we would ask, Your Honor, is that the court consider the evidence and testimony and previous findings as a whole, rather than considering new argument which has either already been presented or does not constitute a new fact or evidence which would merit the court's reconsideration of proposed findings of fact and conclusions of law, with the potential exception of Dr. Cooper's damages, which, as she has stated, have changed over time. Mr. Cedarwall agrees with the position stated and now expounded upon by Mr. Narvaez, that in this case, the proper custodian of records was the Sheriff's Department and the Sheriff himself. And in this case, as Dr. Cooper admitted just now in her argument, Mr. Cedarwall and Mr. Sullivan were not custodians, despite the fact that a records request was submitted to them. And as Your Honor has ruled previously that Mr. Cedarwall was acting as an agent of the county at the time that he was investigating, we would only ask, Your Honor, that the court consider the time frame of when the incidents occurred, when the actions were allegedly taken in regard to inspection and investigation, and when materials existed which could have been produced and when they actually were produced. And again, to consider, Your Honor, that in regard to these 4 requests made by Dr. Cooper, that the county not only timely responded, replied to each request, but also upon a ruling by the court, did produce everything that it had. And as I believe everyone agrees in this case and in testimony, or argument here today, the proper client in regard to the Orchid Cellmark records was not any of the named parties to this litigation. And both, Your Honor, has been provided with evidence that both the county defendants represented by Mr. Narvaez and the defendants represented by our office made attempts to seek those materials from Orchid Cellmark upon the court's direction to do so, and were not given any kind of information other than, we can't respond to you because you're not our client. Furthermore, our office made multiple calls to Orchid Cellmark, and this is also in the record as well, attempting to seek this information or at least speak with the representative, Dr. Lee, who never returned calls to us. So we got one letter, I believe was just the basics of it, just saying, no, you're not our client, we won't give you anything. So even at the point that the court ordered for all defendants to try to get these records, and that was done we didn't go through the subpoena process, but we did follow the court's order and direction in obtaining the materials to the best that we could do. As our clients were not actually the client who apparently submitted records request, or excuse me, not records request, but materials and a request for analysis, or at least review of those DNA materials, which have now been produced to all parties via the subpoena by Tobacco County News, who is no longer a party, as you know. The other reason that we filed the joint response to Dr. Cooper's motion is to preserve the judicial economy and efficiency as much as can be done at this point. Because, Your Honor, we feel that at this point there are no further facts or evidence or testimony which is new in this case or which needs to be further presented or considered. At this point, we feel that it's appropriate for the court to consider the record as a whole and to consider all of the proposed findings of fact and conclusions of law, which are now before you, to reach your final ruling. And the reply is not just to address the argument deficient under Rule 7.1. Rule 7.1 addresses a situation which no response is filed. In this case, we have filed a response, and I just explained the purposes for it being filed in the manner that it was. So finally, Your Honor, I would just ask that in consideration of the records requests as a whole, who the custodians actually were, and the timely responses to each, as well as the later order of production by the court and fulfillment of that production, I would simply ask that the court consider that consider the whole scope of each particular request. They're not very broad. Each one requests a unique type of materials, and I would argue that each of those materials has been provided to the plaintiff, and most of them prior to long before today, and all of which have been provided at this point. I don't believe there's anything further that could be provided. So to argue that a continuing violation is accruing and an ongoing matter, I just don't believe that's accurate. I would argue that, first off, the potential for a penalty should not even be considered or approved because the county did timely address the requests. Secondly, if the court finds that that was not the case and that the penalties might be appropriate, that the penalties only be entered up until the point that compliance occurred. And third, Your Honor, that there is no further compliance to be had. And therefore, as in regard to these requests, and therefore there should not be an assessment of continuing penalties to any party, and especially not to Mr. Cedarwall, as the court has ruled he was an agent of one entity, and it would not be appropriate, or I don't think the IPRA statute requires or allows for penalties assessed by multiple custodians of record for the same entity. So I would request, Your Honor, that you just consider the proposed findings of fact submitted by all parties and evaluate the actual request and consider whether penalties should be, first of all, assessed at all, and secondly, whether compliance has occurred and when, and by which entities at the point of compliance, Your Honor. And finally, I would just request, Your Honor, that the court consider Dr. Cooper's motion not a new motion for any kind of costs, but more just as supplementation to her proposed findings of fact and conclusions of law. And also argue, Your Honor, that there's no basis in this case for Rule 11 sanctions or Rule 37 sanctions. The court has allowed hearings in that regard and allowed evidentiary findings not findings, excuse me, evidentiary testimony, and there just hasn't been any basis shown for such sanctions. Thank you, Your Honor.
Well, this is the first time I've ever done anything like this, so I have the responses of a layman, not of an attorney, and my overall response to my colleagues here is amazement, as if you repeat the same misinformation and lies over and over again, it somehow makes them true, which is the overall thing. IPRA law is tremendously simple. It's made for laymen like me, and I see no evidence that the attorneys or the responsible defendants ever read it. They seem to be winging it and making it up. It's so perplexing. I don't mean to be insulting, but it's absolutely perplexing to a layman to listen to it. Let me go over the specifics, though, and for what actually, let me back up first. I already went over the findings and conclusions for both the parties and showed that there was no basis in fact or law and or anything. And what we've heard is merely a repeating of what was there. And let me just say one other overall thing. My costs and damages certainly are a unique addition. This court in summary judgment has granted me the liability, which leads to the damages and costs. And that's what we're here to decide today. To say that it's part of my findings of fact and conclusions of law is just not to the point. But let me address the specifics of what Attorney Narvaez said first. We specifically sued Sheriff Burden in his individual capacity, Lincoln County, after the first complaint on March 15th of 2007 in the judgment of Mickey Barnett should be removed, and that's why we submitted the amended complaint on November 1st. My defendants were sued in individual capacity as public officials, and that was Attorney Barnett's decision. So it's not quite clear to me what Attorney Narvaez was arguing for Lincoln County. As to the series of arguments that followed on the Vega Brown case that were used both by Attorney Narvaez and Attorney Goulet, I'm not just contending damages under 14-211A through C. I'm contending that for the point of enforcement, IPRA is very clear that it's 14-2-12D, where damages are inclusive of first improper denial by letter, an improper denial letter, then improper denial itself. And that doesn't make the damages double up. It just reinforces that a plaintiff can get enforcement under either impropriety or both, and which is what the Faber versus King case argued. So the improper denial letter is irrelevant. The important thing, though, is irrelevant in the final 14-2-12. But in my case, it's perfect. It's both. They kept on writing back with various excuses to Attorney Barnett's office, but they never produced a letter of denial. That is in the record, the total back and forth from April 24th of 2007 to June 26th of 2007. There is no denial letter. There's just the deputies took them, the deputies resigned, the deputies say they have them, but they're trade secrets. There's just a bunch of stuff that has nothing to do with IPRA, but has to do with the whole purpose of this case, the hope that I'll just go away and they can get away with what they've been doing for 10 years, which is riding roughshod over the law, over the sheriff's department, over their own taxpayers. And it's not just me and these attorneys accruing taxpayer bills. Before that, that sheriff's department was in Grant County, Tobacco County, constantly using taxpayer resources. And I'm saying they have to pay the piper finally. They can't talk their way out of it. And 14-2-12, as Attorney Narvaez said, is not irrelevant. It's the key to settling this case. They are in total violation. They mentioned, as they did in surprising disingenuousness in their findings and conclusions, that I didn't come to their office and look for the records. That's not IPRA. That's not even reasonable. This is not a law that has me searching through offices in Lincoln County. They're supposed to give me the records, either give me the records to look at them or give me the records if I want to pay for copies. That never occurred. And timely must be real. Something has to be done. And IPRA is, again, a very simple law. You have 15 days. You have 15 days to give the records, 15 days to write that very specific denial, which has the explanation, which means IPRA. Give me an exception. No exception was given. Give me the records listed. That was not done. Give me the people who are responsible. That was not done. IPRA says if you haven't done it in 15 days, you're in an improper records denial. IPRA gives only one way out: ask for a burdensome extra amount of time. Within that 15 days, there's no such letter in my pack of responses. That was never asked for. 15 days was their time limit. Nothing happened, but it doesn't matter because nothing has happened since now. I'm just dismayed when both the attorneys are talking as if anything was fulfilled in terms of giving records. Again, as astounding to me as a layman, is repeating over and over, as Attorney Narvaez did, and as Attorney Nicole Werkmeister, who came to this court before, repeated, he has nothing else in his pocket, Judge. What is he going to do if it's not in his pocket? That's not IPRA. That's trying to fool this court. It doesn't matter what's in his pocket. I don't want to hear if it's hard for him, he doesn't know what to do. Sheriff Verdon even asked Attorney Threet if he could give him the address for Attorney Lee. These people are fooling around with my life, fooling around with the court, and fooling around with their own taxpayers, and thinking they can get away with it. This is what it looks like when corruption is out of control. People feel untouchable. And for a plaintiff, for someone who's exposing it like me, there's nowhere to turn. The only thing that's available to stop these wildly out of control defendants is a penalty that won't be forgotten in Lincoln County. Then, again, you got to hear my deputies took them and didn't give them back. The switcheroos and shell games. Well, what was he going to do? The deputies had him. What was he going to do in 15 days? It was totally simple. Write a letter to Orchid Cellmark, write a letter to Dr. Lee, give Dr. Cooper the records. It's that simple. This is an attempt at obfuscation to turn a totally simple case characterized by absolutely inconceivable arrogance of defendants. And a sense of immunity to a law that is totally simple. As Attorney Narvaez has said now for a few years, I've got to listen to it, what more could the sheriff do? Well, you could start by reading IPRA law, and it tells you exactly what to do. You have to get the records. Read Toomey versus Truth or Consequences. It's more available to them than me. They have access to online things that I don't. Read it. It says you have to get them if they're held on behalf. And it doesn't want to listen to you whining about subpoenas and it's hard and how do I get the address. It's irrelevant. DNA is not in the sheriff's possession. It's not in his pocket. He doesn't carry around DNA. Thanks, I thought he did. Come on. We're grown-ups here. I'm just a layman. This is silly. I mean, somebody's got to do the emperor's new clothes on this case. They're naked. Naked. Naked violating the law. Does it mean that we have to send letters? Well, of course it means you have to send letters. That's what IPRA says. Get them however you can. If they're in your possession, you give them. Okay, what about your order where you said you believe they're not in the sheriff's possession? Right. So he has to get them. That's all that it means. You established as a material fact that you believe that it's not in his office. They wanted me to come and look around, but you believe, and I believe, it wasn't in his office. I personally believe they expurgated the file because I know all the records that were in the file since I did the litigation against them in Grant County and Tobacco County, and there are a lot of records missing, not just the DNA records, but whatever. You said that, okay, they're not. That means he has to get them. It's, like I said, only 31 words. Half of them say if the records are in his possession, the other half says he has to get them if they're held on behalf of him, as Dr. Lee did. I'm amazed at the audacity of the defense, though, because we even have the letters from Dr. Lee and from Orchid saying, we got them, we'll give them to you. And then the sheriff does nothing. What did the sheriff say in his deposition? Attorney Morell is here. The sheriff in his deposition on June 27th of last year said, Attorney Morell told me not to do anything else. Attorney Morell told me to stop. Why? Attorney Morell is part of this. I might as well say the truth. Attorney Morell covered up all the records for 4 years by using the criminal exception, and now he's playing different games. It's all games. Lincoln County got caught with their pants down by permitting this hoax to be conducted through a sheriff's department on taxpayer money. Now it's time to pay the piper for having done that. And the last outpost that they're holding on to is these records. As to adopting his findings and conclusions of his client, this is still Attorney Narvaez, they are diametrically opposed to your own orders, and they also make absolutely no sense in terms of law or truth or fact. As to my costs, which was perplexing to me, which made me think they don't even read not only the law but my motions, that he doesn't know how my costs were calculated. I don't know what to say. It's spelled out in my request for costs and damages, and my costs are very specifically spelled out. And I deserve to be paid. I've been burdened for all these years financially. And there's an attempt to plead for the taxpayers that Attorney Narvaez did. They've had 6 years to think about the taxpayers if they were concerned about liability. Not a cent, maybe postage, had to be paid on this case within the first 15 days. Mr. Cedarwall is brought up, and that's always been perplexing to me. Even though everybody is saying he's a hobbyist and not responsible, a fortune has gone out to paying his legal bills. The only thing I could say is the tourism department should be promoting hobbyists, as this is the ideal state because you'll get all your legal fees paid. Mr. Cedarwall has clearly been treated by this court and everyone else as a public official who's just blowing smoke. Then the Attorney Narvaez says all the materials have been presented to me. Not a stitch has been presented to me. I have no idea if this is supposed to be convincing to you or time has to be filled. This makes no sense to me as a layman. As to the continuing violation, he says no. Well, that's wishful thinking, but you have to comply. I have not gotten a denial letter. I have not gotten the requested records. And IPRA says up to a appropriate denial or compliance. That's the only thing that stops the clicking of the ticking clock. The question of what should we do? Do we go against the deputies? It's not my problem. It's not my burden. It's their problem. And that's a spurious attempt to mislead the court, because if Mr. Cedarwall absconded with poor deceased Tom Sullivan with all the records from their file, or in fact never even put them in the record in the file and kept them at home, which some deputies can do, all the sheriff had to do was get on the phone with Orchid Selmark. Rick Staub was directly involved in this case. He was at the exhumation in Arizona to pick up the bones. You call him, hey, Rick, I'm in this legal case. I found out that I lost my records. Please send me another copy. Oh, the client. Tell me who's the client, and I'll contact Calvin Osler. This is not a complicated thing. Now, the thought that my costs and damages should be considered as findings and conclusions seems very silly to me. Liability was decided. We've just been waiting as we went through the revelation that they were also turning out manufacturing records like hotcakes with Dr. Lee. We've just been waiting after the liabilities flow the costs and damages. And so here it is today. It's not findings and conclusions. This is the time to pay the piper. Okay, as to Attorney Brown's law firm for Mr. Cedarwall now, I felt that this extensive verbiage on the joint response essentially said nothing. They did not respond to my costs and damages. They didn't even respond arguing their own findings. They simply referred us to look at them. Are you supposed to make it up? And it isn't even relevant. They have to respond. They didn't. I win automatically by Rule 7.1D NMRA. Again, Cedarwall isn't a custodian, right, but he's still responsible. Nobody stopped him. They were not trade secrets. He had to turn them over. This is a game. I mean, he was so, if you want to measure the arrogance of these defendants, besides my having to listen to this for 6 years, is that Mr. Cedarwall, in the midst of this litigation, took out a website to sell these documents. These people are out of control. Then the representative for Mr. Cedarwall said some kind of double talk about time frames and when materials were produced. No materials were produced. The time frame never happened. No deadline was met. Again, Mr. Cedarwall, and for a time I didn't bring it up, made his own sham records request on February 5th of 2011, again prodded by you. And the court shouldn't lose sight of the fact that they had to prod for years before they did anything at all. 210 is when the forged records started being produced. What did Mr. Cedarwall do? He wrote he knew the client, but he left that out, and he just wrote some kind of general letter to Rick Staub and never gave me any copy of either that signed or any response at all. So I have no idea what they're talking about, but it doesn't matter. It doesn't say that a records requester has to know every single step that was taken to get the records. I just want the records, as I'm entitled to under law. And as to Mr. Cedarwall and the records, he clearly had a direct line to Dr. Lee. All he had to do is call him, say, okay, I have the CD, they need the original. This is just a copy that I was using as a template for a business. a Dr. Lee report business, but give me an original so they'll go away and liability will not continue to accrue. They can say from today till tomorrow that they don't want my cost to accrue or they don't want their liability to accrue, but it does. It's daily, per diem. And why $100? Of course it says up to $100. You can't be worse than my defendants. It's impossible. In the Vega Brown case, depending on the compliance, and there was a degree of compliance with the Sheriff's Office 16 request, it was modulated. But where it was complete, that's non-compliance at its most obvious. That's why IPRA has a maximum. In fact, there's a argument that by not defining damages under 14-2-12D, they can be conceivably more than $100, not less, but more. They said that my costs and damages are no new facts. I'm not arguing the case. It's very clear this is non-compliance. I'm presenting the way of ending this case and stopping the accrual of the damages. I have not heard any argument that has to do with IPRA made by my defendants, in fact, ever, but not today. And I feel that I've argued correctly my costs and damages. And if it's my unfortunate fate to continue arguing this in higher courts, I will, and the damages will continue to accrue. My hope is that we can finish today.
May I respond briefly on behalf of both defense attorneys?
She has not said it. Okay, go ahead.
Thank you. And I will be brief, Your Honor. 14.2.7 sets forth the designation of custodian and duties. Each public body shall designate at least one custodian of public records who shall, A, receive and respond to requests to inspect public records, B, provide proper and reasonable opportunities to inspect public records, C, provide reasonable facilities to make or furnish copies of the public records during usual business hours. So a couple of points here. Lincoln County appointed the sheriff to be the records custodian. And Dr. Cooper candidly admitted to you today and made the statement that Cedar Wall and Sullivan were not records custodians, and they're not. It's not contended that they are, and they're not. So the sheriff is the custodian, and he must either, under B, provide proper, he either has to provide copies, or under B, provide proper and reasonable opportunities to inspect the public records. Here, there are 2 dates of IPRA requests at issue in the complaint. And those are April 24, 2007, May 9, 2007. Those were not directed to Cedar Wall or Sullivan. They were directed to the sheriff. Even if they had been directed to Cedar Wall and Sullivan, the responses were timely made. There is no claim that the responses were untimely. Within 3 or 4 days, they were responded to in writing, and they said, we don't have these documents. There is no information like this, but if you want to come in and look at the documents, here they are. And that, I think, satisfies 14.2.7. Now, the court further has found that the sheriff provided everything in his possession relating to the investigation. The court, I believe the court is bothered by the fact that Cedar Wall accumulated documents, decided they were his as a hobby, and didn't turn them over. Well, that bothered the county also, so that the request, the IPRA request that came in June of 2007, triggered the letter to Cedar Wall and Sullivan saying, give us these documents so we could stick them in the file and turn them over. They resigned. I believe that those requests are the only ones that were directed to Cedar Wall and Sullivan. A, they are not custodians. B, that IPRA request in June 2007 is not before the court in this lawsuit. Judge, I think where we're at, when you're looking at potential damages here, under 14.211, when the claim is that there was not a timely response, the statute specifically mentions up to $100 to be awarded. That's when there is not a timely response. That's when the government ignores the request. That was the situation that Judge Clay Campbell was addressing in this case that was brought before you today. That is not the case that we're here on today. There was a timely response. That's what we urge you to consider. Looking at 14.212, enforcement, I believe, and I would urge the court to consider, that 14.212 would be the statute that you should consider here today. And that is where the court shall award damages, costs, and reasonable attorney fees to any person whose written request has been denied. We responded. We said we don't have the materials. You can come in and look at the file. If you feel that for any reason the request by Dr. Cooper was denied, we think that 14.212 would be the section that the legislature intended for you to consider. Now, it doesn't say up to $100 per day. I think Dr. Cooper is correct. You could maybe consider that. You could consider anything you wanted. But I think it's significant that this one is not mandatory like Section 11 is, and this one doesn't mention any number. I think as an attorney, you ought to try to read the sections consistently, and reading them consistently, in my mind, I believe that Section 11 was intended to apply to a situation where there is no reply, where the request is just ignored. I believe Section 12 is intended to apply to enforcement situations where there is a denial that is unreasonable. And I believe under those circumstances, the legislature intended for the courts to look at damages, costs, and reasonable attorney fees. The attorney fees have been paid. I think the court should consider what are reasonable damages and costs. Dr. Cooper says they are $19,590. The court may consider that request, and the court might even consider, if it decided to use some of the doctor's other figures, she says $966,000 based upon $100 a day. The court could decide to use that and apply a figure, for example, of $1 a day and make that $9,660. I think the court has some discretion here. But I think the court should determine first that the denial was unreasonable. I think the court would be hard-pressed to make that determination if the court has determined that the sheriff did everything that he could to produce what he had and to invite Dr. Cooper to come in and inspect the records as it's provided for in NIPRA. I think that in light of the fact that it's now the law of the case that Cedar, Wall, and Sullivan are not records custodians, I think that it would be incumbent on the court to proceed under Section 12 alone. And I think, Judge, that on behalf of the defendants, we would ask you to do the following for all our benefits. We would ask you to enter findings and conclusions and not make any ruling upon the motion that's before you today by Dr. Cooper, but to first consider our requested findings and conclusions and enter the court's findings and conclusions, and then make any award, if any, based upon those findings and conclusions. We think that would be to all our benefit, including the Court of Appeals in Santa Fe. Sir, thank you.
Before I address directly what Attorney Narvaez said, I want to point out on findings and conclusions under NMRA Rule 52, they're unnecessary in this case. They're unnecessary in decisions on motions under Rule 56, summary judgment. This court has already decided what facts are material to the genuine issues at hand. In fact, this court decided several times. On March 12th, you decided, and of 2010, and on September 28th of 2011, you decided that these records were public and had to be turned over, and the nature of the records. This has not been complied with, but the findings and conclusions were optional all along, and this court's orders constitute findings and conclusions. Those were the the necessary material facts for this court making its decision on my behalf and granting me liability. Attorney Narvaez, and now to address that, seems again to still be repeating optimistically misinformation. 14-2-7, which designates custodian responsibilities, merely says that it's the responsibility of a public body to make available public records for inspection. If you ask for specific public records, those are the records that have to be given to you. Or there has to be an IPRA compatible denial of those records. I was not given any. I was not offered the opportunity to see the actual records, though for some strange reason, Attorney Narvaez makes it seem as if that trip to Lincoln County to search out the sheriff's office would have been worth it for me, because maybe in some nook and cranny, the sheriff had hoarded the records. It's silly. The opportunity to inspect, it just means inspect the records that were requested. I do want to read, though, because there's a misusing of it, the law for 14-2-11, procedure for denied request. This has not been met, no matter how many times Attorney Morrell or Attorney Narvaez would like to say that it was. And in fact, on February 4th of this year, I questioned Attorney Morrell. I gave him the packet of back and forth with the Barnett law firm and himself to have him try to find that so-called denial letter. It isn't there. Under 14-2-11A, it says, unless a written request has been determined to be excessively burdensome or broad, that means exceeding the 15 days, a written request for inspection of public records that has not been permitted within 15 days of receipt by the office of the custodian may be deemed denied. The person requesting the public records may pursue the remedies provided in IPRA. Well, it's not just a general, I don't have the records, tough luck, in 15 days. Obviously, what the defendants are talking about is an attempt to find loopholes that the legislators who wrote this law were well aware of. The purpose of this law is not to let potentially dishonest public officials have evasions. It's not in my possession. My secretary has it at home. The dog ate it. You're not allowed under IPRA to make excuses. So the denial is a legal document showing your due diligence in terms of the request. B, if a written request has been denied, the custodian shall provide the requester with a written explanation of the denial. Nowhere is that in any letter, and you can't even construe it from the multiple back and forths from April till June of 2007. There is no IPRA denial justification in writing or anywhere else, even made to this very moment in this courtroom. That means it's very simple. IPRA is not difficult. It means an exception. There are only 8 exceptions under 14-2-1A. 8 exceptions. They meet none of them, and they use none of them. The written denial shall is a mandatory word in law, shall A, describe the record sought, that's after the written explanation. That's not in any document retyping the records sought. That's why they tried to get away with misstating the records through these 6 years. 2, set forth the names and titles or positions of each person responsible for the denial, and that doesn't mean my deputies took them. And 3, be delivered or mailed to the person requesting. C, and this is the particular damage on that, a custodian who does not deliver or mail a written explanation of denial within 15 days after receipt of a written request for inspection is subject to action to enforce the provisions of the Inspection of Public Records Act, and the requester may be awarded damages. Damages shall, that's mandatory, 1, be awarded if the failure to provide a timely explanation of denial is determined to be unreasonable. That's a second closing of the gate of loopholes for dishonest record holders with something to hide. It can't be unreasonable. My deputies took them. I don't know how to contact the forensic lab. I'm 40 years in the business, but I just don't know. I'm not too swift. They don't ask for that. 2, not exceed $100 per day. There's a reason that it goes from little to big. Violations go from little to big, and you can't get bigger than this. 3, accrue from the day the public body is in noncompliance until a written denial is issued. They still haven't done it because there's nothing to say. I brought this up with Attorney Morell in February, and he still didn't produce the letter in this court. You saw me doing it. But Attorney Narvaez, to get back to him, is trying to blur that to minimize 14-2-12, which is the punchline that IPRA has been building up to. 14-2-8 says there are penalty. 14-2-11 says even if you write an improper letter of denial, you're in trouble with per diem damages. And 14-2-12 is paying the piper. Under D, if your written request has been denied, the court shall award damages. And Attorney Narvaez, oddly, and I just don't know what to make of it when the defendants make up things. He said it's not mandatory. I read it right here, that in Derringer versus the State of New Mexico, New Mexico Court of Appeals, 2003, that the court shall award damages is mandatory. The plaintiff, and that was decided by our Court of Appeals. If we want to go back there, they'll decide it again. The plaintiff is awarded mandatory costs, fees, and damages if the plaintiff is successful in action. Damages are not discretionary and arise from violating the statute. That's scary. It's intended to be scary. Per diem is scary. Now, for big, like Water Safety Act, those kind of penalties are $10,000 a day. These kind of civil penalties are intended to coerce the violator to stop violating. That is Spear versus McDermott, the Court of Appeals here in 1996. Coercive measures are to stop a violator from violating the law. I don't think my defendants like that. They're squirming now. This is the payday. What about my costs? I have no idea why Attorney Narvaez chose to quibble about my costs that are listed other than being vindictively punishing. But my costs are established. They're straightforward. They come to me for having done this litigation. What they really don't want to talk about is $966,000 and counting. Up tomorrow, $400 more. They are mandatory. Attorney's fees. It doesn't say reasonable costs and reasonable damages. They've already established that it's per diem, and they're assuming that that will encourage prompt compliance. They've never thought of defendants like mine who just thumb their noses at courts and law and me. He tells you to try $1 a day. Maybe you'll try 10 cents a day. We're trying to make a deal now with IPRA, trying to get off the hook. And then he says that we should just forget about my costs and damages and just enter findings and conclusions. They're not necessary. This court has decided, liability has been decided for me in summary judgment. It's been repeated. I should now be get the recompense that the law has established.
Hey, folks, I'm not gonna give you a decision, I think I have an idea of where I'm going, but I do need to enter findings and conclusions. You've already submitted them before, Dr. Cooper, you filed.
Mine are February 27th,
February 28th, they filed theirs on
April 24th.
Okay. You know what I need for you folks to do is resubmit them to me, because once a final conclusion gets filed, I cannot alter it, and I usually, it's easier for me if I just have yours, I put them in a file and I can work with them. Resubmit them to me, not for filing, but just, you may just want to send them to my proposed text, that way I'll make a file from those, of the final conclusions I can work with. I don't want any addendums, additions, I want the same ones that you had before.
I was just going to ask that very question in light of today's hearing, if we could make a couple of slight additions or addendums.
No,
Okay, that's fine.
And then what I'll do is, when I give my decision, I'll also incorporate what I've heard today. I need the findings and conclusions. Dr. Cooper, I'm going to just make one note today that any award, if I give you any award, will at the most will be through today. Okay? Let me tell you the reason why. I may not get to a final decision for 90 days or so. Okay? It's no fault of anyone but mine that I wouldn't give you a decision. So I don't want to, assuming I was to award per diem as your request, right? It would not be the defendants doing it, and I didn't get to them for 90 days. So it will go as far as today. So you know that.
May I respond to
Sure.
that? Any decision is obviously yours, but my response for the record would be an objection because it goes against the statutory requirement for per diem, and it really required a proper letter of denial or compliance. You can decide, I mean, obviously I'm not the one to say, but I, for the record, want to say that the violation nonetheless continues. But so that's my own clarification. In other words, I feel like I would be accepting something that wasn't my own argument, but it's the court's discretion to cut off the.
And you made your record, okay?
Yeah, thank you.
Okay. So the only thing I need from you folks is just send me a copy of your proposed findings and conclusions that have already been filed, so I can look.
They don't give me, when you fax file as pro se, they don't give me a stamped copy. Do you want
No, I
the
say,
stamp?
they're not to be filed.
No, but is it okay with you if it doesn't have the court stamp on it?
No, see, if you fax file them, then we have to scan them in and it creates a legal.
No, I'm saying that when I submitted it on February
Right.
27th, they put the stamp on
Right.
for you, but they don't send it back to me. When I send you a copy, which I have at home, do you need the stamp? It's just a technical thing.
No, I don't want the stamp. I want you as if you were originally just sending them to me without filing.
Just like I faxed it to them.
Right, but don't fax it, email it to me.
No,
can
email?
create it.
Okay.
Get a hold of Georgia, okay?
If
I'm not
she will give
allowed
it, I
to.
think we have a copy, we could send you hers, Your
No,
Honor.
I'll take care of mine.
Okay, just-
I don't think I'm allowed to fax to you, Judge Iqbal.
No, I don't want, get a hold of Sandra, she'll explain what we need, okay?
Okay, I'll do it through her, thank you.
And then just email me yours once again, that way I can go with it. Because the file copies, I cannot do anything with those.
I could say one other thing. I included new findings and conclusions in my proposed orders, so that,
I saw
Yeah.
the order.
yeah, yeah.
But I'm working off the proposed
Yeah.
finding conclusions from, okay. And you folks have Merry Christmas, Happy Holidays, and I appreciate the civility in this case. I know it's been going on for a long time, but it's been civil. And Mr. Narvaez has been doing this for a long time, and he's been in some dog fights where they walk in the door, can't even talk to each other. At least you folks are civil with each other. You advocate for yourself, but you're not, it's not personal. All right, okay.
Thank you.
Thank you.
All right,